From Texas is recognized.
I thank the chairman.
May I have 20 seconds, please?
Yes, ma'am.
Thank you.
Let's hear the opposition research.
Thank you. That's absolutely right, that they're not running for, he's not running for office again because, well, I don't know why you're not running for office again, but after the filing deadline, you publicly announced you would not run when your chief of staff, Patty Garcia, announced and took your seat.
That's a state matter. That isn't a federal matter. You should investigate crimes.
Time belongs to the gentleman from Texas. The time belongs to the gentleman from Texas.
Yes.
I asked that today because we're voting on the Save America Act today to enact common sense policies to ensure only American citizens vote in American elections and enact federal voter ID laws. But it's true, for example, that in just this month, a federal grand jury in Newark indicted two men with illegally voting in federal election and making false statements, Mohammed Mazammel and Mohammed Shakil.
A federal courtroom, survivors of Jeffrey Epstein standing before a judge, and the Department of Justice, under Pam Bondi, being accused of doing the unthinkable, exposing the identities of victims while shielding the names of powerful associates through heavy redactions. Let that settle for a moment. The people harmed are visible. The people with influence are obscured. That inversion alone should stop you cold. But it gets worse. This wasn't a leak. It wasn't a rogue clerk. It was an official document release, packaged as transparency, sold as accountability, marketed as long-awaited sunlight on one of the most grotesque criminal networks in modern history. And yet, according to the legal challenge now moving forward, that sunlight may have burned the wrong people.
That's all pending.
But it does not overturn votes that they've cast, right? So passing the Save America Act would help deal with that problem.
Yes, Congressman.
Second question. As Attorney General, you're in charge of the Executive Office of Immigration Review, correct?
Yes, Congressman.
The Biden-Mayorkas regime caused the immigration court case backlog to explode, correct?
Explode.
Does that sound about right that in September of 2020, 4 months before President Biden took office, there was a backlog of 1.5 million cases, but by the time President Biden left office, the backlog reached nearly 4.2 million cases?
It sounds about right, but I don't have the exact numbers.
It would be accurate to say that most individuals who file for asylum have a meritless or fraudulent claim?
Here's what's happening. The Justice Department.
The wrong people. Before we go 1 second further, understand this. If you care about accountability at the highest levels of power, if you refuse to let constitutional decay become background noise, then subscribe, like, and share this video right now. Because what you're about to hear will not be framed this way anywhere else. And once you see the pattern, you won't be able to unsee it. Survivors and their attorneys argue that the release violated the very statute designed to protect them. A federal judge has allowed their case to proceed. That means the court saw enough substance to take this seriously. And when a federal judge signals concern over how the DOJ handled sensitive victim information, that's not routine procedure. That's a warning flare. Now pause and consider the psychological impact. Survivors who trusted the system, again, now say they were re-traumatized by it. Their names allegedly published, their trauma reopened. Meanwhile, the identities of individuals tied to Epstein's orbit remain concealed behind thick black lines of redaction. Ask yourself a destabilizing question. How does a Justice Department reverse the moral polarity of transparency? In congressional testimony days later, Bondi faced lawmakers. 6 survivors were present in the room. They were not shouting. They were not protesting. They were standing, waiting. And according to multiple accounts, Bondi did not acknowledge them. No apology, no eye contact. No indication that the department had erred. That moment matters more than any press release, because power reveals itself in what it refuses to confront. Members of Congress pressed her. Some accused the department of protecting perpetrators while exposing victims. Others demanded internal communications explaining who authorized the release structure, who decided what to redact, who approved victim identifiers being made public. Here's why that line of inquiry is dangerous for the administration. Paper trails exist. And once internal deliberations enter discovery, once emails and memos become evidence, intent becomes visible. Was this negligence, or was it a deliberate calibration of disclosure? That distinction is the difference between bureaucratic incompetence and obstruction. Obstruction is not a procedural error. It's a constitutional offense. Now zoom out. This controversy does not exist in isolation. It sits inside a broader pattern critics have identified within Trump-aligned institutions. Aggressive pursuit of political adversaries combined with hesitation, at best, when accountability threatens powerful networks. The perception, fair or not, is selective enforcement. And selective enforcement corrodes equal justice under law. When transparency is marketed but trust erodes, something is misaligned. Bondi's defenders argue legal protocol required redactions, that privacy considerations mandated caution, that the department balanced competing obligations. But the survivors' legal team counters that the governing statute, written precisely because past processes failed, was intended to override the old culture of concealment. If that argument holds in court, the implications are profound. Because then this isn't about optics, it's about whether the Department of Justice disregarded the spirit, or even the letter, of a law crafted to prevent this exact outcome. And here is the strategic tension building beneath the surface. Epstein's network touched figures across the political spectrum. The redactions are not occurring in a partisan vacuum, which means suspicion is bipartisan. Lawmakers on both sides want to know what remains hidden. When mistrust becomes cross-ideological, instability follows. Now consider Bondi's historical proximity to prior Epstein investigations during her tenure in Florida. Critics have long argued that earlier opportunities for more aggressive prosecution were missed. Bondi disputes those characterizations, but perception compounds. And when present controversy intersects with past decisions, narrative hardens into pattern. Pattern is lethal in politics. The federal court challenge is now a live wire. If the judge ultimately rules that the department mishandled the release, the remedies could range from website restructuring to mandated revisions or judicial reprimand. Even absent a ruling against the DOJ, the fact that survivors had to seek court intervention creates an enduring image, victims fighting their own government for protection. That image does not fade easily. Meanwhile, congressional inquiries are accelerating. Requests for internal documents, demands for testimony, pressure for clarity on redaction criteria. Each hearing extends the story's lifespan. Each unanswered question deepens suspicion. And suspicion is oxygen for constitutional crisis narratives. Let's speak plainly. The Department of Justice exists to administer due process impartially. When allegations arise that it prioritized shielding connected individuals while exposing vulnerable ones, the issue transcends administrative error. It becomes about institutional decay. Institutional decay rarely announces itself dramatically. It emerges through incremental norm violations, through rationalizations, through technical compliance that subvert substantive justice. That's what makes this moment volatile. Because if the court determines the statute was undermined, if transparency was weaponized rather than fulfilled, that signals something darker than misjudgment. It suggests a system still instinctively protective of power, and power, when reflexively insulated, metastasizes. We are also in a volatile electoral cycle. Public trust in federal institutions is already fragile. Stories that reinforce perceptions of double standards land differently in that climate. They don't just inform, they inflame. Imagine the worst-case trajectory. Judicial rebuke, congressional findings, bipartisan condemnation. Each step amplifies the next. Each escalation reframes the prior defense as insufficient. Now imagine the alternative. No ruling against the department. No sanctions. But lingering questions, lingering redactions, lingering doubt. In some ways, that scenario is more corrosive, because ambiguity feeds conspiracy. And conspiracy thrives in silence. So where does this leave us? It leaves us confronting a fundamental question about American governance. When transparency is promised, who bears the cost of its execution? If victims are collateral damage while elites remain obscured, the moral architecture of justice fractures. And fractured justice destabilizes democracy. This is not about partisan spectacle. It's about whether federal power can be trusted to protect the vulnerable when doing so inconveniences the powerful. That is the stress test. The survivors are not retreating. Their legal teams are not backing down. Lawmakers are not finished probing. The judge has not ruled. The documents remain partially redacted. The internal communications have not yet been fully aired. That means the story is still unfolding. And unfolding stories under constitutional strain are precisely when vigilance matters most. If you believe sunlight should not blind the injured while shielding the influential, then do not let this conversation disappear into algorithmic oblivion. Subscribe right now. Like this video so it reaches beyond echo chambers. Share it with people who still believe accountability should run upward, not downward. Because history does not pivot only on court rulings. It pivots on whether citizens stay engaged when power is under scrutiny. The coming weeks may clarify intent, or they may deepen uncertainty. Either way, the stakes are larger than one document release. They are about the credibility of institutions sworn to equal justice. And once credibility erodes, restoration is far harder than outrage. Stay informed, stay relentless, subscribe, like, and share, because the truth only survives if it is amplified.